Okay, so welcome everyone to term 3 of 2018, and thanks for joining us at the first tutorial of our administrative law unit, where we shall be having a discussion about administrative law. And I'm excited to see that we have 28 students joining this particular tutorial. So it's great to see so many students joining us for a tutorial. So that's very good. Now, it's always nice, more than the fact that a lot of you are, enrolled in administrative law because it's required in order for you to become lawyers in Queensland or other states in Australia, because it's part of it's one of the pre-11 subjects. But it's also important to really study administrative law because you're likely to encounter a lot of clients later on when you become lawyers who perhaps need your assistance in relation to decisions made by the executive government. And in all likelihood, some of you or a lot of you would, in your lifetimes, be thinking closely about administrative law, mainly because administrative law, if you've gone through the readings, looks at the system by which decisions of the executive or actions of the executive can be subject to accountability, can actually be reviewed by the executive itself, or perhaps even by the courts, and to a great extent also by Parliament when it decides to enact laws to address weaknesses in executive decision making. And so that's what we're going to be doing tonight. We know that a lot of us are affected by executive government decisions every day. This could be in relation to decisions made by the Centrelink concerning benefits. It could be about decisions made by the Child Support Agency for some of you who've had to go through that process of trying to have how is it called now? Child support allowances being determined by the CSA. So I've been through that process myself. And it could be about, immigration matters. And, there are various ways by which the executive government can make decisions which affect us. And so it's important for us to learn about administrative law. And the advantage of obviously of knowing administrative law is that you then know the ways by which you can potentially have executive government decisions reviewed. Now, if you'll notice, when I talk about administrative law, I made an emphasis on decisions of the executive government. And obviously, the courts make decisions in relation to cases before it and or before them. And even the Parliament would make decisions in behalf of the entire citizenry. But when we speak of administrative law, we're focusing on decisions made by the executive government. And I'm hoping that it is apparent or clear to all of you, the distinction between the executive as opposed to the Parliament, as opposed to the courts. And if that is not the case, I shall take the time to kind of just elucidate a bit about those principles in the course of this tutorial. Now, before I continue, I'd like you, if it's all right, to just say something about yourselves so that we have a better sense of who are at the tutorial and who might be enrolled in our unit in administrative law. So if it's all right, can I ask you to say something about yourselves, like your year level, the state and city of residence, and if you've studied constitutional law before. Can I ask you to do that, please, for just a minute or two? Sorry. I ended up muting everyone. Please unmute yourself. You could actually, use the mic, or you could type in the chat box. I ended up muting everyone at the point that somebody was about to say something. Was it Bronwyn?
Yes, it was. I'm happy to go first.
Yes.
Bronwyn Chamberlain. I live in Newcastle in New South Wales. I'm currently working in a criminal law practice.
Okay.
I worked at Legal Aid for 32 years, so I'm mindful of the way that bureaucracy works and how governments make decisions.
Okay.
This is my final subject.
Your final subject, was it?
Final subject.
Wow.
So I've done constitutional law, so hopefully I'll get a good result here, and then I'll be delving into the criminal law practice.
Okay, very good. Thank you, Bronwyn. Thank you.
Okay.
Welcome everyone again. I'm hearing some background noise there. So we've got Damien, first year from Melbourne. Welcome, Damien. My name, by the way, is Manjo, pronounced as Manjo, like Banjo, or J for Joseph. So Manjo. Okay, just wanted to make that clear. From Nicole, finished first year, then +1 second year subject, live in the Sunshine Coast. By the way, I live in Brisbane. From Kayla, final year from Sydney, and she has studied constitutional law already. Ruth, returning to study law. Sarah, rural Western Australia, second year, and she's done constitutional law. Sarah, Nusa, Sarah Manon, and Nusa in the first year. Sarah Rogers from Brisbane, and she is in her final year. Very good. Okay, so there are some of you who haven't done constitutional law. Now, you don't have to worry about not having previously studied constitutional law. I used to teach constitutional law in CQ Uni for the past 4 years. And I've also been teaching administrative law for the same amount of time. And I've never felt that there was really a necessity to study constitutional law. It is helpful to know some of the constitutional law principles, and I've taken the trouble of providing some resources to talk about constitutional law, at least its broader and more important principles that may have a relevance to administrative law. But I don't get the impression or the sense that it is important for students to really study constitutional law prior to taking up administrative law. So that shouldn't be a problem, because as we go through administrative law, when I feel that there is a need to elucidate constitutional principles, I shall be doing that. We also have Lindsay from Melbourne, and we have Lorraine, who lives in Mackay. Oh, Lorraine, yeah. I am familiar with Mackay. I know it's hot and beautiful out there because I did live in Mackay for about 6 months when I first moved to Australia, because that was where I was assigned initially. So I'm very familiar with Mackay. I lived in Andergrove.
Oh, okay. I live in Marion, so it's a little bit further out.
Ah, okay. Yeah, the only problem I had, well, there were a few things which are very nice about Mackay. The only main observation I had was that, despite the beautiful beaches there, you just can't swim.
Not in summer, no.
Yeah. So when I first arrived in Brisbane, people were surprised when I started asking them, "Can I go swimming here?" Oh, okay. I thought you couldn't swim in any part of Australia. It turns out we're just in the northern part of Queensland.
Mm-hmm.
Okay, very good. So, yep, thanks everyone for taking the trouble of saying something.
Mannion, I'm Queensland, and I'm from Mergen.
Ah, where is that exactly?
Near Kingaroy.
Okay.
Near
Pardon me, but my
inland from Gympie.
Oh, okay. Okay.
Yeah, it's my first year.
Okay.
I've done statutory interpretation and learning law. Now I'm doing this one with you, but I haven't studied constitutional law.
Okay, that's all right. It's amazing how the use of technology, especially with Zoom and before we were using Blackboard Collaborate, how it enables students to actually try to take up a law education. And initially, I had the impression that because I was living in Australia, or I am living in Australia, and you all live in Australia, I initially had the impression that everyone will not have a problem with the internet. So meaning, there wouldn't be issues about lags or, signals, losing signals, or certain areas in Australia not having signals, until I had the chance to go to Tasmania in September of this year. And I went to Port Arthur, which is, for some of you, it's kind of to the south of Tasmania. And I was surprised that there were really parts of Australia that didn't have any signal. The only, there were parts where you could get signal through, was it through Telstra? But Vodafone, if you used Vodafone as your provider, you couldn't have access to the internet. And so that just made me realize that I just couldn't assume that because somebody is in Australia, then necessarily there wouldn't be a problem with having access to the internet. So I become very mindful of that. especially when some students then tell me that, oh, I couldn't get access to do this or that because, and I'm having problems trying to submit this particular assessment because I live in rural or regional Australia. And so it was a good thing to have gone there because, it's a new way for me to learn about how diverse Australia in fact can be, because I just assumed that, everyone who lives in Australia live in the same way, and it turns out that isn't the case. Okay, thank you. Lorraine, did you want to say something? We're good? Okay. Now, so after this session, after the tutorial session, I was reading from Lauren, send some Mackay Sunshine down to us. Have done constitutional law, but in Ireland, it's relatively similar. My background is environmental and anti-corruption law. Fantastic, Lindsay. Yeah, Lindsay was having problems earlier. She was actually an hour ahead in joining the tutorials because I understand Lindsay, I think, lives in, was it New South Wales? And we're there about an hour ahead. So I ended up having 3 students joining the Zoom session an hour ahead because they don't really live in Queensland. And in terms of the time, they're actually, I think, an hour ahead. So thank you. She lives in Melbourne, which is in Victoria. Okay. I do get mixed up with the geography sometimes. Okay, very good. Okay, so after this session, you should be able to explain the purpose of the tutorials and how they would be ran, and be able to discuss and explain the role of administrative law, the relationship between the separation of powers and administrative law, the scope of administrative law, principles and values, and the boundaries of administrative law. So I'm going to take the trouble of discussing a bit more about what the tutorials are about and how we are running them, especially because some of you are quite new to the CQ Uni LLB program. And of course, a lot of it, the way that the tutorials are ran would of course depend on the unit coordinator or the lecturer running the tutorial. But in my case, the purpose of the tutorials mainly would be to really focus on student learning. It's one thing for students to try to learn by going through the textbook, watching the lecture podcasts, or going through study guides. And to me, you can do a lot of you can attempt at deep reading and deep learning using the textbook, but it's different when you go through tutorials, because that is when we try to explore and examine very important concepts and force ourselves to think about a concept because we can continue to ask questions. So when you do reading, for example, it's kind of an approach where you just continue to just plod on and to read, but it's to a great extent, it's quite passive learning that happens there. But in a tutorial, it's an active learning process because you've got somebody trying to facilitate and draw students to discuss and answer questions, and you've got the other community of learners trying to jump in and share their own thoughts. So that's an advantage, I think, in having tutorials, because the learning becomes more active, and it's obviously possible then for us to try to draw on our own experiences, because when you read a textbook or you're reading a text, your level of understanding and your level of learning is delimited by what you're reading. Whereas when you have a tutorial, it's possible for us to share our own experiences and listen to the diversity of ideas that emerge from a discussion. We would have assumed that there is one single answer or there's one single viewpoint, and it turns out that there's a multitude of answers and ideas out there. I also need to emphasize that the tutorials actually provide a safe learning environment. So you can be sure that I never try to embarrass any student. I understand that it is easy to make mistakes. I make mistakes all the time. But the reason why we have tutorials in the first place, and the reason why we're trying to learn in the first place, is that we know that there are certain things that we do not know. And because we do not know certain things, of course, you will be bound to make mistakes. I would be surprised that anyone who tries to learn something knows everything, because if that were the case, that person doesn't have to study. But because we're trying to study, we go into that activity with the knowledge and understanding that there are certain things we do not know and that we are bound to make mistakes. And it should be in that spirit that we try to go through our learning. And even, for example, when we have quizzes, when you have the midterm assessments, and then especially the midterm assessments where you're going to be provided feedback about what went right and about what went wrong, I would suggest that we look at these, the kind of feedback you're getting as an attempt for you to really learn from your mistakes. I recall, for example, there are two kinds of mindsets, for example, because I sometimes do reading on management, and there is such a thing as the fixed mindset and the growth mindset. And some people who struggle with trying to move, progress or flourish or become more successful, they struggle mainly because they have a fixed mindset. And it is, to some people, and I struggle with it sometimes, that they believe that, they've already gotten everything right and that there's no need for them to learn because, they know a lot about anything. But because of the idea that they know everything, their mindset is fixed. They are not really that open to learning. And when you try, when to these individuals with a fixed mindset, when their mistakes are pointed out to them, they react very adversely. And so that becomes a problem. On the other hand, there is the notion of the growth mindset. And these are individuals who recognize that there are many things that they don't know about. And they are very much prepared to learn that what their mistakes may be, because they know that their mistakes become springboards for learning, for growth, and to really flourish. So I wish to emphasize that the tutorials provide a safe learning environment. It will also be an opportunity for us to dig deeper into the concepts and cases. In relation to the question from Mike, yes, Mike, this tutorial is recorded. And then this is one other thing that I'm hoping you should really take on board. The tutorials provide you as students an opportunity to practice giving oral answers. You can practice, speaking in public. And I am surprised that, there are, in fact, a number of students who are quite hesitant to express themselves in a public environment. I wonder if it's the fear that they may commit a mistake, or that they may be criticized, or that other students may kind of embarrass them in any way. But you're trying to become lawyers, and if you will become lawyers, you need to learn the art of argumentation. And if you're going to be appearing in court, if you're appearing in a tribunal, you'll probably be talking to clients. You need to really be good at public communication. And I would really argue that because for a lot of you, you're naturally Aussies, Australians. I'm obviously Asian, and English is not even my first language. It should be very easy for you to engage in public speaking because you're using your first language. People like me, we struggle, or I used to struggle with public communication. And and yet some are in fact hesitant. And I'm hoping that you you use the tutorials as an opportunity to practice the ability to speak in public. It's also an opportunity for students to receive constructive feedback. So when you have the tutorials later on, as I said, sometimes you will be making mistakes, and I'll point out what the mistakes are in a very constructive and in a way that will not embarrass you. But then that you've made a mistake, and the learning is actually stronger and deeper when you've made a mistake. It's what is known as a teachable moment. So, look at this as an opportunity to really learn. And the other thing is that the tutorial is an opportunity for us to be together as a community of learners. Because imagine, for some of you, especially those who may be staying at home, those of you who are likely to be taking care of kids, for some of us, there are limited opportunities for us to engage with others. I myself stay in the house most of the time, mainly because in the LLB program, we teach from home. And so to a great extent, my only opportunity to engage with others meaningfully, if I could even say that, is actually through tutorials. So, and this is a community of learners. This is a group of people with a strong desire to learn. Okay, where was that? So from Lindsay, I will never forget, somebody quite told me many times, and something I've used in my career: there must be a factor of arrogance in order to successfully practice law. You must be strong and must be confident within yourself. Indeed, yeah. True. When I talk to people close to me, I often get the comment that they feel like I'm arrogant, and I wonder if it's because of the fact that I am a lawyer, or it's because of the fact that I don't know. I've always been arrogant, and arrogant people try end up joining the law profession. Although I've seen quite a number of people who are quite modest and they are lawyers, and I'm hoping that I'm actually in that group myself. But who knows? I don't really know. Okay, so we could probably begin. Are we ready to go? Any questions so far? Comments? We're good. Okay, let's begin by answering this first question. Have you had any experience with the system of administrative law, particularly in dealing with administrative or executive agencies, either at the Commonwealth or state level? Have you had to ask for a reconsideration or review of an administrative decision? Please turn on your mic or type something in the chat box if you are prepared to contribute something. From Sarah Goodchild, State Administrative Tribunal count? Obviously, yes, it does. Yes. Sarah, would you happen to have anything to say about it? It could be the QCAT in Queensland, or it could be some other.
I'm in WA, and my mum and I are currently going through the procedure of having to work through the State Administrative Tribunal for guardianship issues for my grandfather, as he's now unable to manage his own affairs. The whole process is turning out to be extremely complicated.
Are you representing yourself, or are you able to do that, or you need a lawyer?
Yeah, so we've got a lawyer in town. There's only one in my little town who set the procedure in motion, but we've all got to go attend actual court in December. So just getting the forms filled out and everything's been really a novel experience.
Yeah. I'd like to point out something, and that is that at the state level, I'm just going to have to mute again, everyone. At the state level, there is kind of a phenomenon that we don't see at the federal level, and it is that at the state level, you can see a combination in a single tribunal or a court exercising both judicial and non-judicial or administrative functions. So I think in NCAT, that's North, what's NCAT? Not sure what that is. That's probably North-South, New South Wales. But in Queensland, for example, we have the Queensland Civil and Administrative Tribunal. The civil component of that tribunal is actually a judicial function. The administrative tribunal is obviously a non-judicial function. That is a crucial point, because at the federal level, you cannot see a combination of a court or a tribunal or an administrative tribunal undertaking at the same time a judicial as well as an administrative function, because it is not permitted under our system of law, under the separation of powers. So, for example, and we're in fact going to discuss this in one of the questions later on, we will see that when we talk about administrative decisions, or those which are being reviewed by administrative tribunals, we will see that there is really no actual controversy between individuals. It's actually an individual trying to arrive at a decision in relation to the executive, to a decision made by the executive, as opposed to a controversy between, let's say, Lauren versus Bronwyn. And in that actual controversy, that has to come before a court. Now, in a federal system, for those of you who obviously studied constitutional law, we will see that courts, because of the Boilermaker's case, can only exercise the judicial functions in relation to instances when there is a matter. And the matter is one where there is an actual controversy involving individuals or involving corporations in relation to rights, liberties, or interests, or legitimate expectations. On the other hand, if you look at a non-matter, you will see that there is actually no controversy, because there is simply a decision made by the executive that impacts on an individual. Now, we're going to have a more chance to talk about this later on. We have a comment here from From Kayla, I actually have a matter that's in NCAT at the moment for a client seeking a review in relation to a firearms prohibition order issued by New South Wales Police. So in that case, from Kayla, we see that the decision was made by the police, which is part of the executive. From Mike, yes, on behalf of a friend dealing with the AAT. From Lauren, I was a single mother for a number of years. My son is now 22. In previous years, I have experienced dealings with both Centrelink and the child support agency. Lauren, we seem to be in the same boat. From Kayla, we prepared an internal review through New South Wales Police, which was declined, and therefore we lodged an application with NCAT. There is a jurisdictional dispute, though. It's all very interesting. From Sarah Manon, child support international through Centrelink. Okay, Australia has treaties with the US. The process, however, has been extremely slow. Okay. And from Lindsay, National Government, review of the Law on Dangerous Drugs Act. I've been involved with rewriting the act, also the National Integrity System. And from Nancy Tran, I've dealt with AAT in my previous workplace when visa applications are refused. Oh, it's a good thing. So we have a lot of you have actually been imposed to administrative law and the review process involved. So that's a good thing. You come on board trying to learn administrative law, and you have a sense of how administrative law can have an impact on you and how you can use your knowledge of administrative law for the purpose of perhaps vindicating some of your rights or protecting your interests. So in question 2, what do you suppose is administrative law about, and what is its scope? What is the scope of administrative law, and what is it about? Am I speaking too fast, or my pace is kind of okay? Because some students say I speak too fast. I get too excited. Is my pace just manageable? All good from Michael. Very good. Okay, thank you. Thank you, Alison. Thank you, Steph. From Tony, I work for local government and I've had so many administrative decisions appealed to SAT. We have them on speed dial. Okay. From Sarah, my pace is fine. Okay. And there is a point from Sarah. Can you discuss how the new Human Rights Act affects Queenslanders when I get a chance in regards to administrative law? Okay, remind me later on. We'll try to get back to that. From SB, where can I find the questions? So the questions we have here in the tutorial, they're actually in Moodle for week 1, although I've added a few questions for this particular tutorial. For Mary, reviewing decisions made by government departments or their employees. So what is, in relation to the question, what is administrative law and what is its scope? The answer of Mary, which is correct, is that it talks about reviewing decisions made by government departments or their employees. Okay.
Is that also in relation to the transparency, privacy, that type of answer in regards to that?
Very good. So that's a good point that Daryl has correctly pointed out, because oftentimes when we talk about administrative law, we assume that it's often about decisions made by the executive that affects citizens. But as correctly pointed out by Daryl, often another aspect of administrative law is actually talking about the Freedom of Information Act or privacy laws. And to that extent, therefore, we can use administrative law as a mechanism to force the executive government to provide information that is meant to be available to the public. So the use of the Freedom of Information Act is also a way by which administrative law can be appreciated in terms of its value, because the study of the Freedom of Information Act and the right of citizens to be given access to information held by government agencies is now in legislation. And when we look at week 11, we then see that part of ensuring executive accountability or government accountability is the ability of government, or the requirement on the part of government, to be transparent in relation to the workings of government, or in relation to its activities, or in relation to its decisions. And the way by which the activities of the executive government can be made transparent and in full view of the public, which ultimately makes decisions on who should be in government, would be to be able to exercise their right to have access, which is a matter of right, to public documents which are in the possession of the government. And when we see later on, and actually this is actually part of I think question 6 later on in the tutorial, we will see later on that on the one hand, we have the idea of freedom of information, but to an extent that is also balanced by a countervailing or a conflicting value in administrative law, which is about privacy as well. So even if the government, the government agencies may have access to certain documents, there are certain constraints where, because of privacy laws, for example, we cannot have access to information that may have an impact on the commercial interests of companies, or if it pertains to the medical records of an individual because of privacy laws. So we will then see that in administrative law, there is often a clash or a conflict in values between, on the one hand, transparency, and the one hand, to the need to protect information and confidentiality and privacy. There's also the conflict on the one hand of, if you notice, when you look at the administrative tribunals, which we discussed, I think, in week 3, we notice that the administrative tribunals have been designed to have mechanisms which are less formalistic, less legalistic, and inexpensive, meaning cheaper. If you look at the court system, if you were to litigate before the courts for the purpose of vindicating certain rights which have been affected by an executive decision, in the court system, you would usually need lawyers. The courts obviously have to follow the rules of evidence, and it becomes more expensive, and it's a long process if you have to go through the court system. So the administrative tribunals are faster, they're less inexpensive, and they're less legalistic and less formalistic. But at the same time, even if there is that value in the administrative tribunals to be quick, to be inexpensive, there is a need, for example, to observe the rules of natural justice, or the requirement that when the rights of individuals or citizens are affected by an executive decision, then they should be given an opportunity to be heard. Which means, therefore, because of the requirement of natural justice, because of the requirement that somebody whose rights, interests, or legitimate expectations can be affected by a government decision, there is a requirement for the government to take things a bit more slowly, to give an opportunity for the person to be heard. So that does have a countervailing effect to the idea of speed, because natural justice requires things to be done a bit more slowly in order to afford an individual an opportunity to be heard. From Lindsay Wilson, pace is fine, largely political, but it is a very broad spectrum, can also be broadly interpreted. Okay. From staff, who determines what should stay private, and can that be challenged if somebody disagrees? The freedom of information. So the question of what should stay private is actually in legislation. That's in the Privacy Act, Commonwealth, and there are privacy acts as well in the states, and that is all stated there. And oftentimes, when we speak of public documents, which we will have to examine in week 11, I don't want to spend time on it at this point. We will know that there are certain public documents that are really publicly open, but there are also certain documents that are not made available to the public. For example, deliberations by the Treasury, deliberations by the Cabinet. These are not open for. There is no public access by citizens, mainly because if everything were to be publicly available, then there is a possibility that ministers or key persons of the executive may feel compelled to not publicly speak out of fear that whatever they say will then be brought into the openly to the public, and they could face a public backlash. So on the one hand, there is a need for the public to know about how decisions have been made by the government, but at the same time, the courts recognize the need for the executives or the members of the executive to be able to debate openly among themselves about certain issues without the fear that whatever they say will be made available to the public. There are also constraints in the Freedom of Information Act, in the sense that investigations conducted by the police, investigations conducted by the Australian Security and Intelligence Organization are not available to the public. And that should be quite obvious, right? Because if their investigations or the way they do things were to be made publicly available, then that obviously is a huge advantage to those who may be interested, who may have criminal designs. So there are limits to what the Freedom of Information Act allows. For Mary, you can also appeal the decision to the RTI commissioner, and yes, some cases end up in court. Okay. And for Michael, needs to be open for precedence. Very good. So I'm sure what Michael is saying here that is that oftentimes a lot of these decisions should be made available because you're hoping that it becomes a guide to the way that other executive decision makers may make a decision at some point. Okay, let's move on because we've got 24 minutes to go, and I am aware that some of you may have tutorials after this particular tutorial. So we're just going to skip that particular question, or is that the same? Okay. Tutorial 3. In what ways can executive government decisions be reviewed? What is your idea, your understanding of this?
It can be reviewed in tribunals,
Mm-hmm.
that type of arrangement.
Very good.
So in the reading of government, like when it goes in the upper house.
Very good. Sorry, what about the upper house there, Darryl?
When you read, when the bill goes to the floor
Uh-huh.
and it gets voted on, it goes through, then it goes to the upper house. The upper house goes and does their own review on it as well. Maybe approve it or disprove it.
Okay. Comments to what Darryl has contributed? What do the others think?
Is that not through the process of a legislation, like when a bill's being passed? I was under the impression that executive government decisions.
So, Sarah, were you responding to what Darryl was saying?
Yes.
Okay. So I think Sarah was saying that when it comes to bills and attempts to enact a law by the Parliament, whether at the level of the state or at the level of the Commonwealth government, that is actually part of constitutional law. That is not part of administrative law, and that is actually correct. So when we speak about administrative law, we're actually looking at decisions made by the executive. So this could be decisions in the form of because of internal regulations, or it could be because of subordinate legislation, in the sense that there are certain powers issued to the executive government as a result of a primary legislation passed by the Parliament. So it is decisions of the executive that are part of the system of administrative law. But when we speak about bills passed by the Parliament, or especially when we try to talk about questioning the validity or the constitutionality of laws or bills passed by the Parliament, that is actually within the purview of constitutional law. That is a crucial point, because when we speak of executive government decisions, and somebody has already talked about judicial review or merit review from Sarah, when you speak of government decision, the traditional ways or the conventional ways by which you seek a decision of the executive to be reviewed is actually either through the courts, through the system of judicial review, or through merit review, which is through the administrative tribunals, such as the Administrative Appeals Tribunal in the federal government. On the other hand, when you are questioning the constitutionality, for example, of a statute passed by the Commonwealth Parliament, there is no system by which you can question the validity or constitutionality of that particular law before, for example, the AAT. Because in that particular case, the executive does not have the power to review the constitutionality of a law. That only belongs to the courts. Now, we will later on see in the case of Breyer Lawler Automotive, New South Wales versus Collector of Customs of New South Wales, that there will be instances when somebody seeks a review of an executive decision before an administrative tribunal, for example. There will be instances when there is an attempt to question the validity of a law or the validity of a statute. Now, it doesn't mean, we will see later on, that simply because the validity of a law has been raised before an administrative tribunal, that particular tribunal, therefore, loses its jurisdiction. It continues to exercise jurisdiction over the executive decision, and it does have the power to examine the validity of the law. But any determination made by the administrative tribunal in relation to whether or not a law is valid is not conclusive. It is not conclusive because only the courts can do that. But according to the case of Breyer Lawler Automotive, of course, when you look at merits review or a review by the administrative tribunals, they actually examine not only the merits or the factual correctness or whether or not the decision by the executive is correct according to the requirements of government policies and so on, but it also has to take account the fact of whether or not the executive decision is according to law. So when a merit review is conducted by the administrative tribunal, by necessity, they have to consider the lawfulness or the legality of the decision, including the underlying law behind the decision. But any attempt at making a determination by the administrative tribunal is not conclusive because in our system of government, under the separation of powers, only the courts have the power to interpret the constitutionality or the legality of a law. From Kate, she says that one way by which you can also have a review of government decisions is actually through the ombudsman, and that is correct. Oftentimes, we realize that it might be better to just go to the ombudsman for the ombudsman to examine the need, to examine the decisions made by the executive. And more importantly, from Ruth, and this is a crucial point, it is often more beneficial to seek an internal review of a government agency. So in other words, when the executive has made a decision, whether it could be the Centrelink, it could be a visa officer, it could be the child support agency, you shouldn't go straight away to trying to go to the administrative appeal tribunal or trying perhaps to examine, an attempt to go to the courts. When you talk to an officer is trying to make a decision, and because this has happened to me, and you tell them that you are prepared to seek an internal review, all of a sudden they realize you might just know something about administrative law. They become quite wary and cautious because they don't want their decisions to be examined by somebody superior to them, because they don't want their somebody say you're wrong. And because I have a sense that to a great extent a lot of these functionaries in the executive department, they're so used to citizens, to individuals just accepting decisions that they think they're never going to complain. So those few individuals who actually tell them, look, you have to be careful about the decisions you make, because if I don't like your decision, I'm going to seek an internal review. Then that stops them for a while. They think, oops, this person knows something. So yeah. Okay, from Sarah, hang on, can we ask for an internal review? Okay.
Can you give an example? Obviously for me, for example, going through Child Support International, I can actually ask for an internal review. I don't think so.
Yes. So Sarah, if you're unhappy with a decision of the Child Support Agency,
yes.
So in other words, you're not satisfied with the decision because the decision may be wrong according to you, and the way that they appreciate the facts. They failed to take account of certain facts. You feel that they did not take into account certain factors as required by statute or as required by the internal policies. And especially if you think that their decision is contrary to the law.
Yes.
You can't.
Is that done by writing or is that done over the phone?
It depends on the agency. Some of them would agree to do it through the phone, but oftentimes they'll ask you to do it in writing. I'll give you a very specific example. And this involves me. In the Child Support Agency, I'm not going to identify my ex-wife. So let's just say it's theoretical, okay? Because I don't want to get into trouble. But there was a written agreement. So we had a consent order, which was at the Federal Circuit Court. Okay, we had a consent order, and we had a side agreement, a written agreement, where we agreed that until one of the kids was going to turn 18, we will not seek child support from each other. It was in writing. If you study the law of contracts, that written agreement is valid. It is valid. Now, The problem, however, is that the child support agency says, sorry, but we cannot accept your written agreement, even if it appears to be valid in law. They're not even aware that it's valid, but they say, according to our internal policies, it has to be a document that has to be in writing, and it has to be signed by your respective lawyers. Now, we missed that part. I wasn't aware that there wasn't a need for that. And so I told them, look, guys, that's your internal policy, but as far as the law is concerned, this is a contract that is valid. Now, if you say that you're unwilling to recognize the validity of this contract, I can tell you, I'm going to go to a Queensland court to enforce my rights through specific performance. And I don't really know. It's still pending out there. I don't really know how they will decide, but I'm just saying there is an advantage to knowing the law. So there is an internal review process, and I've told them that if I'm unhappy with what you've done, I have three ways of dealing with this. I can ask for an internal review because I am questioning the validity of that internal policy. And I told them I could go to the Administrative Appeals Tribunal to ask the AAT to make a determination that that policy is contrary to the law. So you have to revise your policy. I told them that. Or thirdly, I said, I'm gonna exhaust my remedies through the courts. Okay. Where was that? Okay, so we can proceed. Very good. 646. Now, did that answer your question, Sarah? Sarah Manon? It did. Okay, very good. Thank you. Tutorial question 4. How would you distinguish administrative law from other fields of law? Example, constitutional law. So from Lindsay, I have been through this with my ex. It is not an easy process. Yeah, because it's not just the legality of it all, it's the emotions involved. And you've got kids. Anyway, how would you distinguish administrative law from other fields of law?
Hi, I said basically that it was one of the major ways was by the parties involved.
Okay, go on.
Like you said earlier, so like normally in, say, for example, civil law, you would have person A and person B, and then you would have the civil law in the middle. So the parties are different for each set. For example, criminal law, you would have the Crown, and then you would have a defendant.
Very good.
And then the criminal law in the middle. So, and each set of law, it would be slightly different.
Very good. Very good. Okay. Thank you, Sarah. I just got a feedback here from Michael. A comment. I get the theme here. Don't get married. Michael, I wish it were that easy. Yeah. Some people were telling me, sometimes after you've divorced and you remarry, it's sometimes the triumph of hope over experience. Isn't that right? It's the triumph of hope over experience. I mean, you've got it wrong the first time. Why do you bother doing it again? But hope, reigns supreme sometimes in human beings. It's probably a good thing, though. Otherwise, yeah. Okay.
Executive decisions have caught us out on that as well. You go live with someone for 6 months or whatever the time frame is, and you bug it anyway. See, we should appeal that one.
I wish it were that easy, Daryl. Yeah. Okay, let's just go to question 5 because I wanted to talk a bit about constitutional law. Why is it important to have some understanding of constitutional law principles, particularly about the separation of powers, or separation of judicial powers?
All right, I'll have a go at this. It's important because, as we were talking about before, with issues around constitutional law, they can look a lot like administrative law issues in that it's there's an issue that, say, a citizen raises with the legality of a law, which looks like a government and citizen interaction, therefore to be covered under administrative law, but it's actually not, because it's about the dispute isn't between the person and the government. It's actually about It's actually, if there's an issue about something being unconstitutional, it's actually between either the Parliament. There's an issue between the Parliament and the executive, or the judiciary, the courts and the executive.
Very good. Thank you. What do the others think? Why is it important to have some understanding of constitutional law? And this has something to do with the legal concept known as matter.
It is important because in order to take an action, you have to have what's related to matter, which is standing. So depending on who you are in the dispute would depend if you have a matter in the case. So if, for example, the courts only have jurisdiction, like you were saying, between individuals where there is a controversy, so there has to be something involved in that particular case. So in order to take a case, you have to have standing and a substantial matter. And the separation of powers is important because you need to determine whose role is what and when they overstep the boundaries then.
Thank you. Yes.
And it's Bronwyn, I'll have a go as well. In terms of the separation of powers doctrine, executive make the laws, and it's the role of the judiciary to then interpret them. But I think the significance in terms of an administrative law, have they exceeded their bounds of power constitutionally and legislatively? And it's really a matter that goes to the judiciary under your separation of powers doctrine to make that determination.
Very good. Now, let me just clarify something here. The reason why, and so you've all been correct, from a theoretical viewpoint or from an abstract level, we need to understand that following the Boilermakers case, the High Court has said that it is only federal courts which can exercise judicial power, and that federal courts cannot be vested with non-judicial power. What exactly is judicial power? Judicial power, really, you can only exercise judicial power when there is a matter. So there is only a matter when there is an actual controversy between parties, between individuals, between an individual and a corporation, involving certain rights, involving certain obligations, and so on. So, for example, when you look at this at a concrete level, when the executive makes a decision, at that point, there is still no controversy. At the time you go to the executive to ask the executive government to make a decision, there is really no controversy at that point. So if we had requested that that the courts immediately, if there had been a chance by which, for example, at the level of the Commonwealth, where an individual goes to the court in order to ask the court to determine whether that person is eligible under a particular law, that would be a theoretical concept because there is really no controversy. So let's say if I go to a court and say, am I entitled to centennial benefits if I am against vaccinating my children? If you were to do that, that is a hypothetical case. There is no matter because there is no actual controversy. And so the requirement for judicial review at the federal level is that there has to be a matter which is an actual controversy involving rights or obligations between individuals. Now, at the point where the executive makes a decision which might be adverse to you or an individual, then that perhaps is the time that there might be an actual controversy, which means therefore you can go to the courts because there is an actual controversy. But before then, you cannot go to the courts to try to ask the court to, consider the legality of to determine whether or not you are entitled to certain rights, because there is no matter. Now, the curious point is that at the level of the Commonwealth, therefore, there is the idea of a separation of powers, separation of judicial and non-judicial powers at the level of the Commonwealth. So because of the Boilermakers case, it is clear that courts, that it is only federal courts which can exercise judicial power, and that you cannot vest non-judicial power in federal courts. So for example, you cannot have a law which says that judges may determine whether or not it should allow the police to wiretap certain folks, because in that particular case there is no matter, there is no actual controversy. That's really an administrative function that is not allowed by at the federal court, at the level of the federal court, because that would breach the separation of judicial powers. However, you will notice that at the level of the states, you have tribunals such as the Queensland Civil and Administrative Tribunal. When you have the idea of a civil tribunal, in all likelihood that involves an actual controversy between individuals. It could be about small contracts. It could be about the failure to do this or that. But that is an actual controversy. So at the QCAT level, you actually have a court. But at the same time, you notice that it is also an administrative tribunal. And yet you think, but didn't it say that, according to the Boilermaker's case, a federal court cannot be vested both with judicial functions and non-judicial functions? So how is it that at the level of the state, you have the QCAT, which exercises both judicial powers and non-judicial powers? And the reason for that, when we examine constitutional law, is that at the level of the states, there is no separation of powers. So at the level of the states, it is permissible for state courts to have both, to exercise both judicial powers and at the same time, non-judicial powers. And the reason for this is that historically, when you look at the history of the states, which used to be colonies of the UK, in the Westminster system of government, the states had the same powers as the Imperial UK Parliament, where at the level of the UK, there is what is known as supremacy of Parliament. So in fact, state courts do not have the power to declare as unconstitutional a state law generally. So state courts, because of the supremacy of state parliaments within the state courts do not have a power to declare as unconstitutional a state law, except to the extent that that state law may breach the Commonwealth Constitution. So that is the only exception there. So if a state law breaches the Commonwealth Constitution, then state courts can declare the law to be unconstitutional. But otherwise, within a state, the state parliament is supreme, and state courts do not have the power to declare as unconstitutional a state law. That is different altogether at the level of the federal court, because as we know, courts have the power in our system of government to declare as unconstitutional any law passed by the Commonwealth Parliament. And it could be because of the violation of the Australian Commonwealth Constitution. So which is why it's important, because when you examine, for example, the Administrative Appeals Tribunal, you know that the Administrative Tribunal does not have jurisdiction over something which involves an actual controversy. So let's assume that you have a dispute in relation to...
Excuse me.
Sorry, yep, what was it?
Excuse me, Manuel.
Yes.
But my internet's unstable and I'm not picking you up. This is recorded, isn't it? I can get this later?
It is recorded, yes, yes.
It's intermittent. I've had the IT man in, but I have to get him back.
That's all right. It's recorded. I'm going to put it up in about 2 hours after the tutorial. Yeah, so don't worry.
Thank you.
Now, going back to the Child Support Agency, so let's assume that there is a decision that has been made by the Child Support Agency, and you are unhappy about the decision. You will notice to an extent that there seems to be a controversy between you and your partner, your ex-partner. Okay, so the question is, when you go to the Administrative Appeals Tribunal to question the decision of the Child Support Agency, is there actually an actual controversy between you and your ex-partner? Right? I mean, that's a good question, isn't it? So the Child Support Agency has made a decision which you are unhappy about. It's against you. It's favorable to your ex-partner. So obviously, you want to have that decision reviewed, and you can identify another party that has benefited from that decision. So there seems to be an actual controversy. So if you go, therefore, to the Administrative Appeals Tribunal, so I'm not talking of the level of the Commonwealth government, the question is there a matter? Are you actually going to be impleading your ex-partner for the purpose of having a decision of the of the child support agency reviewed? And the answer is no, because if you were to implead your ex-partner, if you were going to make a review of the decision and ask your ex-partner to appear before the AAT, there would have been actual controversy between two individuals, and that would be a violation of the separation of powers at the Commonwealth level. So if you were to go to the AAT, you're actually going to be asking the AAT to review a decision of the child support agency. So there is no actual controversy there. And so therefore, in that particular case as well, when the child support agency makes a decision, because it is not making a decision involving a matter, you will realize that there is really no system of precedence, judicial precedent, in the sense that because the AAT is not part of the judicial system, there is no notion of res judicata, or there is no notion of judicial precedent because it is not a court. Okay, I've now seen some moving out because they've got a class in evidence and proof. So I think we've covered most of the key questions, and I think this might be a good time for us to end the tutorial. Before we end it though, would any of you have any questions? Because I've seen a number of you dropping out. We had about 39 earlier, there are now only about 29 of us. Any questions before we end tonight's tutorial? None? Okay. So I'm very happy that a lot of you joined tonight's session, and thanks. Our first quiz comes out on Monday of next week, and enjoy the rest of your night and the weekend up ahead. And thanks for joining us. See you soon. Good night. Bye. Thanks for your participation. Bye.
Hello.
Yeah. Was there a question? Yes.
Can I ask a question?
Go ahead.
It's Sonia. This is my first time using Moodle.
Mm-hmm.
So I'm just, the questions that we went through.
Yes. Hang on. For those who want to leave, you can actually go if you like. You can stay behind. Yes, Sonia, go ahead, please. Sorry.
Thank you. Sorry. Yeah, I just can't find where the questions are. Are they the ones that are in the forum?
Yes.
They're there, are they? And then you just added a few of the others in.
I did, yes.
Okay. All right then. So next week we'll be discussing question 5, which is about the disability support worker, Sharon Hill.
Yes, that's right. Yes.
Okay. All right. So it just took me a little while to find. So.
Okay. Very good. Thank you, Sonia.
All right.
Manjo, sorry, I was just going to ask as well. Sorry, I do apologise. With regards to the problem questions, I've been working my way through them. I was wondering, I know we'll be discussing them in the tutorials, but are there kind of model answers that you would put up afterwards to see where we could go? Oh, you will.
So the only model answers I don't put up are the ones for week 1, because they're essentially just introductory and just trying to get a sense of what others think. But there will be model answers in writing at the end of the tutorial, and I do answer each question during the tutorial, but there will be a model written answer to each of the discussion questions.
That's great. Thank you.
Very good. So good night, everyone, and see you soon. Thank you. Bye.